on how to conduct a cross-examination. I will just share something that happened a few days back with you all. So how we came to do this webinar in the first place. So I was discussing this with Shivangsh and I keep getting confused with their names. They are so similar. So basically Bansal and Joshi, as to doing a webinar on criminal litigation. They wanted me to do a few webinars on criminal litigation. I thought, okay, fine, let's do one on cross-examination because I was watching The Good Wife a few days back and I thought, wow, this is something which has a lot of scope of training, right? You can train people in cross-examining way more than in any other aspect. And a lot depends on cross-examination. So that's what was going on in my mind. And then I thought, okay, fine, this one we'll do on cross-examination and let's do another with Mr. Mir, because I had the opportunity to judge a moot court competition recently conducted by Calcutta University, and I heard him there, and it was like, he's a person who knows how to train people. So let's do one with him as well. But when I was speaking to Mr. Mir, he somehow read my mind and he said, let's do on cross-examination. So that's how we are here with Mr. Mir to train you on how to conduct cross-examination. He will share based on his experiences of setting up cross-examinations in some of the leading matters, and you'll hear from him how he managed to win those cases for his clients. So thank you, sir. Thank you for being here today. So let's start with examination in chief. That's something that's kind of neglected. We keep talking about cross-examination, but how important is examination in chief and how a public prosecutor or sets up an examination in chief, and how is it different from civil cases?
Thank you very much, Madam Sanchita. It's a matter of my pleasure to be amongst all of you. I believe mostly law students and lawyers. And I would like to begin by saying that all of us are duty bound to interact with young lawyers, peers, even elders, because it is only through interactions that we can learn more, share more, and definitely pass on to the next generation of lawyers of what we have learned at bar for many years. So besides how I was introduced, let me say that I'm basically a criminal trial defense lawyer with about 25 years at bar. And I have a pan-India practice. I go to trial courts almost everywhere, wherever I can. And I've had the good fortune also to do some cases which may be termed as sensational, or where there was some kind of media intrigue, be it the 2G Spectrum trial, or the Arushi Talwar Hemraj double murders, or defending MLA Kuldeep Singh Sengar in the Unnao rape case, or trying a 16-year-old juvenile, probably a flagship of borrowing American concept of trying 16-year-olds as adults in the Ryan School murder case at Gurgaon. So the cardinal principles remain same. Besides, whenever any lawyer steps into the field of litigation, it's very essential that he ingrains in himself and bestows to himself a strong, formidable time in trial court practice, and learns the nuances of criminal trial, how evidence is recorded, how witnesses are set up, how these witnesses are cross-examined, and how to strategize a civil trial or a criminal trial. Then, if you seek to proliferate your practice and go to High Court and Supreme Court, as far as your litigative processes are taken into consideration, you are definitely having a solid edge in comparison with respectfully of others who may not have that kind of a trial exposure at all. Because ultimately, in all litigation spheres, what you are arguing is disputes which emanate from recording of evidence, besides some constitutional issues as well. So, before one sets up a strategy for a cross-examination or chief, it is necessary for every defense lawyer or a prosecutor, both in a civil case or a criminal case, to be thorough with what docket has been supplied. So the duty for a criminal lawyer, if he has a defense brief, starts when he's handed over a copy of the charge sheet, which is filed by the investigating authorities, or a complaint, say, by those authorities which are not police under CRPC, let's say like Narcotic Control Bureau, like you would have seen recently in Shah Rukh Khan's son's case, or DRI, or Customs, or Enforcement Directorate. They are not police officials, but they are law enforcement agencies, and they file a complaint. Police files a charge sheet, but the nature of the prosecution remains same. So your duty starts with rummaging the charge sheet. Why is the charge sheet supplied to an accused? Is the recognition of principle of odi alterum partem, that look here, Mr. X or Miss Y, we find that you are involved in commission of a criminal offense. We have got substantial evidence to put you to a trial. We don't want to take you by surprise. We respect your rights of fair trial, fair investigation, fair procedure, due process of law under Article 21 of the Constitution of India. So here is the charge sheet. The charge sheet would obviously contain, one is a summary of investigation done by the investigating officer, along with a list of witnesses and a list of documentary evidences that the prosecutor chooses to rely upon in order to prosecute your client through the length and breadth of the trial. First duty, therefore, is that we make a strong analysis and a chronological note as to how the criminal offense so attributed to your client has been set out on clear timelines, and how the investigation has progressed, whether there are any delays, whether the delays would be fatal in itself. Then what your keen eyes look for is to see that if there is a charge, for example, in Unnao rape case, you will have a charge of 376. In a case like Arushi Talwar Hemraj, you will have a charge of double murder. In a case of 2G Spectrum or coal scam case where I am, for example, defending steel tycoon Mr. Naveen Jindal or his company Jindal Steel and Power, the case would be you indulged in some sort of corrupt exercise, which is punishable by 7 years if convicted. So you would see, besides the chronology of events, what kind of witnesses have been relied upon, what are the statements of those witnesses, how they have been recorded, whether all witnesses' statements have been given or not, and what is each witness saying in his 161 statement. So a criminal lawyer, before he sets up an examination in chief, he doesn't straight away go to the court and stand. You would therefore see that whether the prosecution has examined all the witnesses relevant, whether the prosecution has withheld some evidence, whether the documentary evidence which is available on record and filed along with the charge sheet indeed is original or not. So every civil or criminal lawyer has to have a very strong panache for going through Indian Evidence Act and the procedure, that is CRPC 1973, besides have a knack of connecting the constitutional rights under Article 21 in favor of his client. So therefore, sometimes when your clients are being prosecuted, say by federal law investigating agencies like CBI, most of the time though it's a duty bound in terms of fair investigation, which is your fundamental right, they would seek to conceal exculpatory pieces of evidence. Now, this is, a process of development. For example, when you go to England or United States, the fair disclosure of evidence collected during the course of investigation is a statutory right, which means, for example, in England, it is governed by Attorney General's guidelines on fair disclosure. There, what happens is when somebody is charged for a felony, say a rape or a murder or anything else, aggravated, broken teeth, broken legs, if the investigating authorities during the course of examination have laid their hands on exculpatory evidence, they are to give to the accused and his counsel exculpatory evidence first to begin with. Inculpatory evidence will come later. What happens in India is, if you're getting prosecuted by CBI, you will only see inculpatory evidence. Exculpatory evidence, they'll never show. So first thing is read your charge sheet. Now, then have a detailed conference with your client, depending upon what the charge is all about. Say your client is indicted for corruption, and it's a matter pertaining to documentary pieces of evidence. And during the course of investigation, he had supplied pieces of documentary evidence which exculpate him from the matter. But the investigating authorities then say that, all right, fine, we are here to prosecute you. We will not place exculpatory evidence on record. What do? We file a motion with the court, an application that, Your Honor, the investigating authorities are deliberately trying to conceal vital pieces of evidence which are exculpatory in nature, which are very much relevant, very much necessary and desirable for a fair trial, because fair trial is a constitutional guarantee. So therefore, if the investigating authority chooses to conceal exculpatory evidence, they not only deny me my constitutional rights, but they also tend to play a fraud over the court. Because at the end of the day, the purpose of investigation is the search of truth. And wonderfully, there is a Rajasthan High Court judgment written by a judge who may not be very greatly known as Justice Krishna Iyer or Justice B.P. Jeevan Reddy. And in a judgment called Nilesh Jain versus State of Rajasthan, paragraph 50, if my memory serves me right, their lordships say that investigation is a quest for truth. And the investigating officer is under a duty to work like an archaeologist and to brush the layers in order to reach that truth. However, in his zeal and over enthusiasm, he cannot have an approach to book the accused come what may and look over or trample exculpatory evidence. For the investigating officer is not to just resort to Ashwadhama Maro, a very famous Mahabharata anecdote, without telling who died, the man or the elephant. So from there, we get a quintessential quest of others that investigation as well as prosecution has to be fair. First, your eyes will look for exculpatory evidence. Why do you look for exculpatory evidence? You look for exculpatory evidence because at the time when the matter goes to a trial after charges are framed, how are you supposed to cross-examine a prosecution witness who may be coming down in a court to take your client apart, to confront him with exculpatory evidence recorded by the investigating authorities themselves? And for that, the tool in your hand as a defense lawyer is an application under 207 of the CRPC, read with 91. There is a latest judgment in 2020, I believe 2019, called Nitya Dharmanand, which seeks to reassert two fundamental judgments. One is Manu Sharma and one is Shashikala. But the Indian Supreme Court did not exploit the exculpatory evidence only in these two judgments. It is starting right from Privy Council Pulukori Kotaya that the investigating officer cannot conceal. However, whether he conceals or not, first duty is to see where is the relevant record. Why do you search for relevant record? The relevant record which escalates the innocence of your client needs to be in your hand, so that you can call it into play during the time when the evidence is recorded. So my friends, remember, first point is rummage the charge sheet. You should have a tiger teeth memory on how the charge sheet and the charges have been laid, how the matter has been investigated, what was each stage with timelines. Important aspect of a criminal prosecution, if it's bodily offenses, is always crime scene. What is there on crime scene? Whether the crime scene is discovered at the earliest. You will see in most of the charge sheets, crime scene is docketed by a site plan. So sometimes when the cops go down, they make what you call as unscaled site plan. Then a properly scaled site plan. Then in order to build the case further, they call the relevant evidences, the relevant witnesses. That is the power of 160. That is why 160 says that during the course of investigation, if investigating officer thinks that President of India is acquainted with the facts and circumstances of a case, he will give him a notice under 161. Even the Prime Minister does not have any immunity from that. He'll have to come down and talk to the IO. If the investigating officer deems that, yes, this is a relevant witness to the case that he is investigating, he will record his statement under 161. Now, that statement under 161 is not signed by the witness. Now, there has been an amendment that sometimes and invariably now, the statements of witnesses should be audiographed and videographed as well. Why are these statements recorded? These statements are recorded so that you can have uncolored version of what happened from the mouths of the witnesses at the earliest. Because if you give a time lag, then the versions may get doctored, they may be tutored, they may be, the witnesses may come under influence, they may give a statement at the desire of somebody or on account of vengeance or having a vested interest against somebody. Then you will see a provision in CRPC which is called as 164. In common parlance, we call it as Kalam Band Bayan, which means that the investigating officer deems that this witness is so important, maybe tomorrow he turns turtle in the trial. So let's get his statement recorded under 164 before an executive magistrate or a judicial magistrate first class, in a state and metropolitan magistrate in Delhi or in a metropolitan area like Bangalore, Bombay, Delhi, Chandigarh, wherever they are. Now, what is that statement? That statement is that the magistrate says that, do you want to make a statement voluntarily? Yes, Your Honor, I want to make it. Are you under any kind of threat, coercion, undue influence? No, Your Honor, I am not. Do you want to still make that statement? Yes. Now, please tell me what happened. Ultimately, the witness signs that statement. That statement also is then anecdoted. It is then redacted by the investigating officer in his case diary. After all the evidences are collected, which may be oral testimonies recorded under 161, then strengthened under 164, the investigating officer may then go for collecting, collating other pieces of evidence like forensic opinions from doctors in criminal felonies of bodily offenses. You will have a post-mortem report. You will have a DNA analysis report. You will have a biological report. You will have all kinds of opinions from doctors, whether injuries can be caused by this weapon or not. You will have a ballistic report, and then they will be also collated. And finally, a charge sheet will be prepared under 173(2). This may be an affirmative charge sheet. This may be a closure as well. Now, when your eyes rummage for all these, you have to see initially make a table. It's usually a good criminal lawyer. What he does is he makes a table, a tabular form of all the witnesses in order and summarizes them. He writes his testimony in cut forms, event to event. So witness number one states 4 events. Now, whether witness number one, what he has stated, is contrary to what witness number 2 is stating, or he's improving upon him, or whether both the persons are saying the same thing. Why do you do this? So that you can make a note of inconsistencies, if any, right at the beginning of preparation of trial. This is why a charge sheet is given. Secondly, when you are confronted with forensic documentary pieces of evidence, say forensic reports. Now, you may not be, a lawyer may not be a DNA expert, but when he has a DNA opinion, which is coming from CFSL Delhi, CDFD Hyderabad, what do? You immediately, if your client can afford, you go to a private forensic, a former forensic from the government who now provides an opinion or advice in this field, either for prosecution or for defense. And you tell them, sir, this is a DNA report, and according to me, it is against my client. Now, what the hell are we going to do with it? So he will tell you how to meet DNA evidence, how to build a cross-examination, how to see the technical expert of the witness, and how to destroy that witness in the cross. So you will also then have those people already in your armory. You will engage them on behalf of your client, and then you walk into the trial with some amount of confidence that, yes, now I'm ready. You can't just simply walk into the court and say that, yes, please step forward. Who are you and what you are all about? I'm going to take you to cleaners. That doesn't happen. So my friends, before we set up the examination in chief, be very, very thorough with the whole trial, with the whole charge sheet, each and every witness prepared. Because when a witness comes, you don't cross-examine a witness from the point of view of what he says. You cross-examine a witness from your core defense theory. So when you rummage a charge sheet, when you counsel your client, when you take a factual narrative, you also get to know what your core defenses are. For example, in Unnao rape case, when I was defending Kuldeep Singh Sengar, he told me that, Mr. Mir, at the time when I am alleged to have been to be sexually assaulting the girl, I'm not in my house. Please have my mobile records checked. I have 2 mobiles. And both of my mobiles, right from 11 o'clock till about 12 o'clock in the night, I'm not in my house. I have it tracked. As a matter of fact, even CBI had investigated it. And at the time when he is alleged to have been committing this felony, he's about 17 kilometers away, making phone calls. So your core defense is known to you. Then you go with some amount of confidence that this is what I'm going to say. And I'm going to elicit questions from the mouth and give those answers and suggestions in order to have my client exonerated, to show on record that my client is innocent. Ultimately, what a civil lawyer or a criminal lawyer does is not indulges in some kind of a constitutional debate. We are not about right of privacy. We are about what is examination in chief and what is cross-examination. Ultimately, the two are compared by the court at the stage of final arguments. If the court comes to a conclusion that, yes, the evidence which has been laid is not cogent and convincing, then invariably you may be able to secure an acquittal for your client. Now, what do we do when the chief starts? My understanding is that the duty of a cross-examining lawyer is doubly important in chief as in comparison of the cross. Why is that so? Very simple. If a witness comes to the court, you have to understand what is evidence. Evidence is of only 2 forms. A witness who is permitted by the court to step into the witness box and give an oral testimony after taking an oath. Secondly, a documentary piece of evidence which is original, not duplicate, not a photocopy, not a colored copy, not secondary piece of evidence. and produced before the court for its inspection. Very simple. Documentary evidence will be admissible before a court of law and will be sought to be exhibited by a witness through the prosecutor only under section 62. Therefore, every cross-examining lawyer has to have a detailed study and understanding of section 60 of the Indian Evidence Act and onwards. So if you see chapter 4 and anybody has it before him, very quickly I'll tell you and show that chapter 4 of oral evidence deals with oral evidence. Oral evidence 59, proof of facts by oral evidence. 60 says oral evidence must be direct, which means that if I saw it, I should be the person who should be saying that, yes, this happened in my presence. If I perceived it, I should be the person, yes, I perceived it. So it should not be hearsay. It should not be a third-party testimony. So what do? You have a strong grip on chapter 4 and chapter 5. What is chapter 5? Documentary evidence. Everybody has to read, understand, and collate the different Supreme Court judgments, High Court judgments, which have interpreted and put these provisions to scrutiny. Why is examination in chief and role of the cross-examining lawyer important? A, to raise an objection if the witness starts indulging in doing two kinds of acts. A, talking irrelevant things. B, talking here and say. C, casting an opinion. Now, if you see that under 60 of Indian Evidence Act, no witness is permitted by a court of law or by law to cast an opinion. So let's have a look. Please see proviso to section 60. Thank you, Sanchita. I'm so thankful to you for loading it on the screen. So while as we deliberate, we can also then have an analysis of why it is important. Most of the time, we feel that even prosecutors don't know how to regulate an examination in chief. And most of the time, the witnesses, start talking about their grandmother's details. Court demands, at the end of the day, only relevant evidence. So have a look at 60. Oral evidence must be direct, must in all cases be direct. When the legislature says direct, which means that it cannot be indirect. Then have a look at also, let's go back, Sanchita, and we can come back to the provisions of section 5. Let's go back. I'll just show 3 provisions and then, I'll have this whole aspect debated by you. So please go and have a look at, let's go to section 3 first. And in, yes, what is evidence? Yes. Please come below that. Fact, relevant, fact and issue, document, and evidence. Yes, evidence. Evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. So if the court is doing an inquiry, court is holding a trial, it has to be in relation to facts which are there before the court. 2, all documents, including electronic documents, produced before the inspection of the court, such documents are called as documentary evidence. The 3 definitions there below are also important, not from, say, purely at the moment from examination and cross-examination, but also final argument point of view, because there are only 3 things in law all over the world, whether you are in England, United States, India, Singapore, anywhere in the world. Either it is proved or it is disproved and not proved. So you need to have a grasp on. Now come see, have section 5 for a minute. Let's go to section 5. How do we curtail a court? How do we curtail a witness? We curtail it on the basis of Section 5. Evidence may be given of facts in issue and relevant facts. Evidence may be given in any suit or proceeding. Suit would be a civil suit. Proceeding would be a criminal trial or any other, maybe an inquiry as well, of the existence or non-existence of every fact in issue and other facts as are hereinafter declared to be relevant and no others. So what is fact in issue? If we go back to the definition clause, you'll see there is fact in issue. Let's take it about. Yes, fact in issue. We just had it. Expression fact in issue means and includes any fact from which either by itself or in connection with other facts, existence, non-existence, nature, extent, right, ability, disability asserted in a proceeding. For example, in Arushi Talwar Hemraj double murders, fact in issue is who committed those dastardly double murder. That's the fact in issue. Whether the parents did it or not, whether the servants did it or not, or whether the outsider did it or not. In terms, therefore, by Section 5, any witness which is brought by the prosecution will talk about only that fact in issue and a relevant fact, not grandmother's lullaby. So what do? The moment witness starts proliferating, casting aspersions, taking opinions, going left, right, and center, deviating from the fact and issue, here you are as a defense lawyer, objection, Your Honor. Yes, Mr. Counsel, what is the ground of objection? Objection is, Your Honor, statement is not relevant to the fact and issue. Objection, Your Honor. What is the ground? Objection is, Your Honor, that the witness is resorting to hear and say. So you have to be doubly alert in the examination in chief. Not only on what the witness states, but also whether the witness is prodded, whether the witness is led, whether the witness is handheld. That is not allowed either in a civil trial or in a criminal trial. Though in civil trials, what we now do is accepted procedure is examine in chief by an affidavit. So the pleading gets cut, pasted, and then he comes in a cross, but not in a criminal trial. You can't have evidence. So घर पे आप जब मर्जी तब किसी से भी बनवा लीजिए. That cannot be done. So if somebody is coming to testify in a murder, in a rape, in a dacoity, in a felony, in attempt to murder, in dowry debt, abetment of suicide, narcotics, drugs, money laundering, he's there to take you apart. If he succeeds in testifying against you and his testimony stands as cogent and convincing, thank you very much, your client is going to Tihar jail in the first available bus, and permanently and for perpetuity. And you will not be able to then discharge your duty. So besides first going to the procedure of Indian Evidence Act as to how a chief is conducted, what's your duty, you need to understand first and have a tiger teeth grasp on what is the nature and interpretation of evidence. What kind of evidence can be led in a court? What kind of evidence is permissible in a court? That is not, it's not rocket science. It's just a matter of reading by your heart with your open eye. Remember, a trial lawyer, a litigating lawyer, his passion in his life is first law. Everything else is secondary. Now let's go back to Indian Evidence Act and let's come straight away to the chapter of recording of evidence. And for that, I'll ask Sanchita to have on record the chapter 10 of Indian Evidence Act. Let's see a couple of provisions as to how chief is regulated, how the chief starts. Why do you cross? Is cross mandatory or not? Is chief mandatory or not? What are the exceptions and what are the general guidelines? Now, chapter 10, yes, it starts with section 135. Two provisions which are unknown, nobody talks about it. but they have great vitality in every criminal trial, are sections 135 and 136. See 135, order of examination of witnesses shall be decided by the court and shall be regulated by the court. But let's have a look at 136, judge to decide on admissibility of evidence. Now, how does the judge decide on admissibility of evidence? Admissibility of evidence also means admissibility and sustenance of an objection or recording the entire procedure of evidence, how evidence will be recorded. What is that? What the witness will be permitted to say, and what is that? How he will be cross-examined. So 136 is of great importance. It says just to the judge to decide the admissibility of evidence. When either party proposes to give evidence of any fact, the judge may ask party proposing to give the evidence in what matter alleged fact, if proved, will be relevant. So the PPs does not have an immunity from 136. If he proposes to get a witness to the court, he must be talking and giving an anecdote, not only in compliance of Section 60 of Indian Evidence Act, but also in compliance of Section 6, Section 5, read with 136. That, Your Honor, is a relevant evidence. I have recorded his statement. His statement is available under 161 or 164. That has already been supplied to the accused, so that accused is not taken by a surprise. That who is the witness suddenly walking into the court and recording the testimony? I'm not even prepared. That is why the docket of oral evidence is given. Now let us come straight away to section 137. Examination in chief. The examination of a witness by a party who calls him shall be called his examination in chief. So prosecutor gets a witness. In a case of 376, rape of a woman, the woman is the most important witness. Obviously, the prosecutor will call her to testify. But even her chief will be regulated in terms of assertions, factual narrative, relevant to the fact and issue, not from 1942. What happened? You have to come to the core of the offense and relegate yourself to that alone. The moment you deviate, duty of a cross-examining lawyer starts. If he fails to discharge, he murders his client. Now see, examination in chief, then 137 says cross-examination. The examination of a witness by an adverse party shall be called his cross-examination, then re-examination. The examination of a witness subsequent to cross-examination by a party who called him shall be called as re-examination. So there are only three kinds of examinations are therefore permissible: chief, cross, and re-examination. But importance is that direction of re-examination is not to introduce the theory once again. And that is in section 138. The re-examination shall be directed to explanation of matters referred to in cross-examination, and if new matter is by the permission of the court introduced in re-examination, adverse party may cross-examine. So if in the cross-examination, the witness said something which was altogether different in comparison to the chief, prosecutor may re-examine by filing an application. Again, filing of an application is very important. Sometimes what prosecutors do is railroad you in the trial because you, A, are not prepared. Secondly, bereft of evidence. You don't even bother to read. So he says, sir, man, I'm re-examining right now. And the lawyer, just stands in the court and looks like a cuckoo. What the defense lawyer there is to do, no re-examination, Your Honor, without first filing an application on record. Let him file a notion and say why he wants to re-examine the witness. Remember, wherever the prosecutor seeks re-examination, he is on tenterhooks. His case is taken. That's why the re-examination is being called, which means that it presupposes the fact that in cross, the witness has said something which is not to the liking of the prosecutor at all. So he's uncomfortable. Remember, my friends, whenever re-examination is called for, insist on a written application. Why? Because written application then becomes a part of the record. Tomorrow, if there is a conviction and something atrocious has taken place, the appellate court can look at those pleadings and then come to a conclusion that entire procedure was unfair. So the whole trial has vitiated. We are hereby only on this ground, entitled and moved to acquit the man, lock, stock, and barrel. So many times you have seen it. There are judgments to that extent. Then please see, 139 is to produce a document, and then you will see that. See now, two provisions, then I'll take you into a debate. 141 and 142, please. So everybody would be perplexed that sometimes, you will see in movies or otherwise, or you will see in Netflix, the lawyers coming and saying, objection, Your Honor. Where does this objection come from? Why does a lawyer object? Where is this objection in CRPC? Is objection defined in a CRPC? No. Is the right to object defined in the Indian evidence in section 2? No. Where does it come from? It comes from section 142. Have a look at 141. Why is there a statutory covenant on leading question? Direct statutory covenant. Have a look at it. 141. Any question suggesting the answer which the person putting it wishes or expects to receive is called as a leading question. There are two aspects very important to a cross-examining lawyer. When the prosecutor or a complainant counsel, as the case may be, is getting a chief recorded, is he trying to handhold or lead the witness in a particular manner? So is he asking a question to the witness directly? Or is he suggesting an answer in his question? Can he even ask a question to the witness in the examination in chief? To what extent can you ask a question in the chief itself? Is always a debate before the court. And still it intrigues all courts, whether it is trial courts, appellate courts, revision courts, and Supreme Court. It's not been settled. It's a challenge that the lawyers community and the society faces on a daily basis. But the statutory covenant is there for you to read, understand, and grab. Please emphasize, never forget two words. What are those? Wishes or expects. So sometimes you may ask a question, a PP may ask a question, say in a rape felony, that, Madam, please tell the court, in the evening hours of 1st of January 2022, did you go to the house of the accused? That would be an atrocious question in a chief. So it's an objection, Your Honor. Now, Mr. Mir, what is the ground? Leading, Your Honor. Not only initially, but on the material aspect of testimony. How does the prosecutor ask such a hilarious and horrendous question? That's the objection. Where is the objection? In 142. Have a look at 142. When they must be asked. And when they are to be asked is, leading questions must not, see the language of the legislature, must not, if objected to by the adverse party, be asked in an examination or in re-examination, except with the permission of the court. The court shall permit leading questions as to the core matters which are introductory or undisputed, or which have, in the opinion, already been sufficiently proved. When they may be asked, again defined by the Indian Evidence Act. People, this is all Smith's evidence coming from England, but this is a beautiful piece of a book, which is relied upon in each and every country in the whole world, even Saudi Arabia. Let me tell you that there is a kinship. Because ultimately, anybody prosecuted should only be prosecuted, not persecuted. If you fail in your duty to object when the objection is necessary, what you are doing is not only hurting the interests of your client, but also sending him into a spiraling toss of persecution. So there cannot be a leading question in the chief at all. Now, 90% prosecutors ask leading questions and then they fight like wolves in the court. What is a leading question and when can it be asked? So in an example in a chief, what question is permissible? Say in a case of 376, you can ask, how old are you? All right. How old were you on the date of the incident? Were you living at this address? Is it correct that your educational qualification is this? Is it correct that you are a resident of Delhi in Malviya Nagar? Then the duty of the prosecutor fairly so is to leave the witness on the material aspect of the testimony, on quote unquote fact and issue, and let the witness talk on his own from his memory. Then the witness will say that, sir, I reside in this village. On 1st of January 2021, I met my boyfriend and he asked me, let's go for a drink. After we had a couple of drinks, we both decided to go to his house, where against my will and my wish and my consent, I was sexually ravaged. My clothes were torn apart. That's material. On those material aspects of the testimony, no leading question, no hand holding is allowed. If anything is done, it's your duty, normally, statutorily, ethically, and legally to object. This is where objection jurisprudence arises from. Most of the time, if you ask, sir, how do you object and where is this objection? Nobody knows. But it is all there in the statute. So when a chief is recorded, your eyes and ears should be open. You should be there in the court, near the prosecutor, near the witness, to see what the witness says. Does the witness say anything which is irrelevant? Object. Deviate from fact and issue? Object. Hear and say, if a witness says, for example, sometimes in 376 cases, both the mother and the accused, the victim are witnesses. So mother comes first. A court says under 135, court shall regulate the production of witnesses. Now, where I am a defense lawyer and I am faced with a situation where there are two witnesses of same kind, I always then file an application under 231. What is 231? Madam Sanchita, let's have 231, subclause 2. Let's go to 231, subclause 2 of CRPC. Remember, my friends, any good astute trial lawyer, he has to have an elephantine memory of the procedure. That's what you are permanently married to, nothing else. You can't seek divorce from what you do on a daily basis. That's the statute and the law and the practice. So 231 subclause 2 would say that a judge in his discretion may permit the cross-examination of any witness to be deferred until other witnesses have been examined or recall a witness for further examination. When do you do this? Sometimes in a case, there are 3 witnesses who give a common account. So mother and daughter are giving a common account. Mother is saying that my daughter told me that I was assaulted. What would you do if the mother comes first? You would file an application under 135, Your Honor, mother should not be allowed to testify. And the court will say, why? You'll say, Your Honor, if we, in a case of 376, have the girl, she's the first hand, she's section 60, she's 60 subclause 1, mother is not. So let the girl first testify. Then let the mother come if the prosecutor still wants her. Most of the time, first the grandmother will come, then the mother will come, then the mosi will come, then uncle will come, then the girl will come to the last. And by that time, all your cards are disclosed, your case is finished, your client is looking at nothing less than 10 years of transportation. So it's not just standing there and having umpteen cups of Indian tea. No. You have to be well versed with each provision has a power which can be exploited. Or exploitation may not be a good word, which can be used in accordance with law. So if the mother would say and come say that my daughter told me that something happened to me, you'll say objection. This witness ought not testify to begin with. Secondly, I object to her testimony. Court will say, Mr. Counsel, on the objection is on what ground? Your Honor, I have the main court. The prosecutor has the main witness. This is not res gestae, that the main witness is, this is not a dying declaration. That somebody died and just before his death told his anecdote to a writing magistrate, as it happens in 304B cases, dowry death. Or somebody got assaulted and murdered and he said that mujhe to jo hai ji fala aadmi ne goli maar di. Now the person is dead, then the other man can testify. In normal case, therefore, it is your duty to say, sir, I object. For what? Under section 142, under 135. First of all, आप बोले, sir, objection है, पर मुझे नहीं पता मैं objection किस ground पे दे रहा हूं. These are the provisions that you use. So you will not allow recording of testimony of an indirect witness if the direct witness is available. So you will say, Your Honor, direct witness first, indirect witness later. Sometimes there are two direct witnesses, two persons can be providing a testimonial account of what happened on the crime scene. Then you will use the power under 231. That, sir, please record chief of A, record chief of PW2, defer them both. I'll cross-examine them one by one. Why? Because if you ask me to cross-examine the first witness, I'll then disclose all my cards. The next witness will come and roger me. There, my right to a fair trial will be severely compromised. So remember, my friends, we have to have a strong knack and understanding of what the CRPC as well as Indian Evidence Act before you say that I'm wearing the white band so proudly and the black cord. I'm here to subserve the interest of justice. Remember one thing, as criminal lawyers, you bestow tremendous amount of duty in the society. Though you never liked, everybody hates criminal lawyers. People pursue that, they always defend the criminals. But remember one thing, if criminal lawyers don't stand, every person in the society will get slaughtered. That's the rage of the dispensations all the time. You are there to protect rights. In a democracy governed by principles of rule of law, that law is higher. Howsoever high you may be, law is higher than you. Yes, you have a right of prosecute, not to persecute. Prosecute fairly, in accordance with law, in accordance with procedure. What is procedure? Procedure is due process of law, which is fair, which is reasonable. Not to railroad you in a court of law. So examination in chief, you will look at how the witness is testifying. Most importantly, there are judgments, for example, V.K. Mishra versus State of Uttaranchal. Famous judgment of Tehsildar, constitutional bench judgment. Those we can call into play in the cross-examination. Examination in chief, we talk about oral testimony, direct, relevant to the fact and issue, and witness not to be led. Leading question only introductory. The moment witness comes on material aspect of the testimony, he is swimming, Your Honor, on his own. You can't be, Your Honor, holding him and giving him a life raft. No. Why? He's there. If he testifies, you're getting 10 years. So the procedure is fair to him. Procedure is fair to you. Where does the law say that the prosecutor is not having the legal capability to come and refresh the memory of the witness and show him the case file? He can prepare his witness in terms of his statement. That is his right. But once the witness is in a court of law, he is now then not to hold the hand of the prosecutor or the complainant counsel. He's there to testify. That's his duty in the society. Very well. Retribution, criminal prosecution is a must. Persecution is not. So you are that instrumentality, that tool in a court of law in a society who ensures that fair prosecution is the order of the day. That's robust democracy.
You were just now talking about preparing the witnesses. So one important aspect would be, how does one prepare one's own witness for cross-examination?
Yes. See, as far as preparing witness by the defense is taken into consideration, that is after the prosecution witness is over. Prosecution has closed its witness. Just as
so before that, if I may also ask you the question, since we are on cross-examination, you were talking about prodding witness. So
yes, prodding the witness in the court means you're trying to lead the witness. You're trying to tutor the witness. You're trying to ask the witness to testify in a particular manner. If that is done, it's totally illegal. That is why there is now a concurrent, that is why what Justice Dhananjay Chandrachud is now pushing and pursuing. All trial court proceedings need to be videographed. Why? Look, appellate courts need to see how the witness is testifying. Sometimes it is very difficult to decipher from record as to what happened in the trial court. Now, let me tell you from my experience point of view, if you are doing an examination in chief in metropolitan areas, it's quite decent, all right, fine, Delhi, Bombay, Bangalore, other places, people are well educated. But if you land in Haryana, Uttar Pradesh, then you're having a dangal in an agricultural field. So there is a lot of bunkum going on. On practical ground zero situation, it's very difficult to handle those cases. And sometimes lawyers start bashing each other up. The judges also run into their own chambers. So what is most important is that now there is a concerted effort, record everything digitally. Very good. At least the lawyers will be well behaved. The prosecutor will be better prepared. जैसे वो अपना advertisement आता ऊपर वाला देख रहा है. Then there will be a clear record what happened in the trial court. How did the witnesses testify? Were they prodded? Were they led? Or were they not? At the moment, irrespective of videotaping or not, the defense counsel is not going to lay his eggs that everything is getting videotaped. I'll remain quiet. Why is it important for you to object? If you do not object, now entire recording of evidence is procedural. If you do not raise an objection, you waive your right. That is second aspect of examination in chief. When there is documentary evidence, say a prosecutor pushes a photocopy. Is photocopy an admissible piece of evidence? No, it is not. Why? Sanchita, let's have section 62 of Indian Evidence Act on the screen. Let's have 62. Yes. When you come to section 62, that is chapter 5, you'll see how is documentary evidence proved only by primary evidence or secondary evidence. So what is primary evidence? Primary evidence under 62 is document itself produced for inspection of a court. Where a document is executed in several parts, each is primary evidence. When the document is executed in counterpart, both. So a document which can be proved as evidence in a court of law is original and original. Sometimes the investigating authorities will collect a photocopy, original kabhi seize ही नहीं किया. अब साहब एक गवाह आ गए, document कैसे साबित होता है? the person who authored the document is the person who is empowered in law to exhibit the document or to prove the document. So you can't have one person coming to the court and exhibiting the entire court record. No, that can't be done. Though sometimes that is attempted. Again, you have to object. Why do you object? If you fail to object, then that evidence gets exhibited. And tomorrow the court says that, look here, you were not alive to the situation. Therefore, we can do nothing now. Let me give you an example. If a photocopy is on record and you object, then the prosecutor is alerted that, look here, I have a hitch in my case. He may tomorrow file an application and get the original on record. If you do not object, then at the final hearing stage, you can't say that, sir, this is inadmissible. No, that is not going to work. So it is your duty to object during the course of the trial, because this is procedural law. Again, if it is a photocopy, law provides that you can make a declaration under 63 that, Your Honor, I am not in possession of the original. Give me a permission to lead secondary evidence under 65. Please take it down to 65 is there on the screen. Everybody can see. Cases in which secondary evidence can be led. So there was an agreement to sell in original, which was to be proved in a civil suit. It has been burned down. It is lost. C65C, where original has been destroyed or lost. So you will make a declaration, file an application, then get the witnesses to testify on what actually happened. That is permissible in law. And again, an examination in chief will have to be recorded. So remember, my friends, in examination in chief, if documentary evidence is being exhibited, be alert that only the original is there in the court. If there is no original, object. So what will be the objection? Your Honor, I object. Okay, objection is recorded to the effect that this document is not original, and therefore this document is exhibited only for the purposes of making a record, and admissibility will be decided at the stage of final argument. There you fulfilled your duty greatly. Now you got a crisp examination in chief to deal with the cross. How do you cross? In cross-examination, there are 4 chapters. Remember, my friends, 4 distinct chapters. Chapter 1, Chapter 2, Chapter 3, Chapter 4. You go in a chronological order. He who does not follow these chapters can never cross-examine in his life. First chapter is chapter of contradictions. Why is contradiction necessary and of great pertinence to a criminal trial or a civil trial? Let's say criminal trial. If the witness contradicts himself, that witness has recorded a chief, but that chief is contrary to the statement recorded under 161, or also contrary to the statement under 164, then contradiction is there for the taking. Now, if you see the provision of 162 of the CRPC, let's have Sanchita 162 for a minute. Because you can't learn cross-examination if you don't also appreciate the statutory covenant of what I'm talking about. Contradiction always entails 3 statutory provisions: 161, 164, read with 162, and read with 145 of the Indian Evidence Act. So what does 162 say? No statement made by any police officer in the course of an investigation shall be reduced, if reduced by the person making it, signed by the person, or of record wherein police or doesn't save enough, provided at an inquiry or trial in respect of any offense at the time but submits. Provided when such system witness is called for the prosecution in such inquiry or trial whose statement was recorded in the writing, any part of his statement, if duly proved, may be used by the accused and with the permission of the court by prosecution to contradict. So where is contradict? Contradict is not somewhere in Indian Evidence Act. Contradict is in CRPC. That is 162. Now, if you go now to 145, quickly, 145, how do you take contradiction to a logical conclusion? Cross-examination as to previous statements in the right. A witness may be cross-examined to a previous statement made by him in writing or reduced into writing and relevant to the matters in question, without such writing being shown to him or being proved. But if it is intended to contradict him by the writing, his attention must, before the writing be proved, be called to those parts of it which are to be used for the purpose of contradicting. So therefore, contradiction under 145 is clearly guided in chapter A of cross-examination. What are your keen eyes looking at? Again, you're going back to your initial analysis of the charge sheet and the structured analysis of the witness statements. In a case of sexual felony, the complainant came and gave a written complaint. So you will break it down event by event. Say you have 12 events. Then she records a 161. Then she records a 164. She's taken to a doctor for medical examination. She gives an anecdote. You make a record as that as well. So you have 4 previous statements in writing. Or she also wrote a love letter to her boyfriend or something of that sort. That's the 5th statement in writing, if it is on record. Then there is the examination in chief. Now your contradiction will be, is there a contradiction in the examination in chief in comparison to the previous statements? So what is the trick? Trick is that you show the previous statement and ask the witness that, sir, did you record this statement with the IU? Yes, sir, I did. Is this your statement? Yes, sir. I'm reading the whole statement to you. Do you recollect having this making statement? Yes. When this statement was recorded, did you acknowledge it to be true and correct? Yes, sir, I did. Now, please say, sir, that this portion, what you have said in the chief, is it recorded in your 161? No, sir, unfortunately, it is not. So you're not seeking an explanation. Remember, a cross-examining lawyer doesn't ask a question why you did not state. If you ask that question, you're finished. You don't introduce an explanation. You only exploit a contradiction. What is the importance of these statements under 161 and 164 is to lock the witness to a testimonial account. Remember, both statements 161 and even a signed statement under 164, these are not substantive pieces of evidence. They can only be used for 2 purposes by anybody, be it the defense, be it the prosecution. That is confrontation or corroboration. So sometimes even judges are confused. I find it very strange. I read a judgment where Supreme Court someday convicted somebody on a 164. But Supreme Court itself says that 164 is not substantive. What is substantive piece of evidence is a statement which is recorded in a court of law in presence of the accused. Why is 164 statement, though signed by the maker and signed and given before a magistrate, even by an oath, after an oath, not a substantive piece of evidence? Because it is not made in presence of the accused. It is made behind him. इसलिए हमेशा हम ये कहते हैं कि साहब जो 161 का बयान है या 164 का कलमबंद बयान है, these, Your Honor, my Lord, are not substantive pieces of evidence. That's what the law is all about. First chapter, my friends, is to bring on record the confrontations by the contradictions in the testimonies in regard to previous statements by confronting in accordance with the procedure under 145. So only that portion. So you will say that, sir, in your examination in chief, you have said that on 1st of January, you reached the house of the accused at 9 o'clock. But in your 161, sir, is it correct that when you recorded your statement with the IO, you said I reached at 2 o'clock? So the question answer may be yes or no. Fine, leave it there. Why do you leave it there? Tomorrow, If the contradiction goes to the root of the matter and is a deadly contradiction, then that part of the evidence recorded in the chief is expunged from judicial record. When the judge sits down to write a judgment, the contradicted portion, if it goes to the root of the matter, is taken out of judicial record. That means it is taken out of judicial consideration. So if there was an import, say in a case of, again, I'll say a sexual felony, like Unnao rape case, though there is a conviction, there is an appeal. The girl in a written complaint says, I was sexually assaulted at 2 o'clock. But in her testimony says, I got sexually assaulted at 8 o'clock. But how can you get sexually assaulted at both the times? That's a contradiction which goes to the root of the matter. Hence an acquittal. Likely so in future or not. That's the destiny of the client. So first chapter is take down the witness on the road of contradiction. Therefore, have a tiger teeth grip on 160, 161, 162, 164, read with 145. One judgment I recommend is a Bible. 5 judges bench, Tehsildar, the famous lantern case, and Justice Bhanumati's judgment in V.K. Mishra versus State of Uttaranchal. 2 judgments and you will attain mastery on what contradiction is all about. Second chapter in a cross-examination is merit cross. So you take a witness on merits and test him on merits. Now, on merits, you go back to the provision of Indian Evidence Act, Section 143. Let's come to Section 143 once again. When can leading questions be asked? That is only in a cross-examination. Now also have a look at Section 155. What is the provision of Section 155? Impeaching the credit of the witness. Why is Section 155 introduced by the legislature? To empower a cross-examining lawyer. There is a witness, your Honor, he's a liar. Why? Look, I asked him 10 questions. He went, on a roadmap throughout the evidence. So he has all broken down. So merit of the cross is always fact-based. You will use 2 provisions, 155 and 143. Impeach the credit of the witness. Test him on merits. Somebody says 9 o'clock, I went to a particular place. Did you walk? Did you take a cycle? Did you go by bus? Sir, I took a bus. Do you remember the number? Can you say it to the court? Did you say it to the IO? Do you have the ticket? Can you give me the color of the date? Color of the gate. Now, that is very important for you to do a crime scene inspection. Say somebody says, sir, I walked into a place. पता चल रहा है कि वो तो साहब जो है घर में बैठा हुआ था और झूठा गवाह बन गया. So he will not know the structure. He will know whether the stairs were from north or from the south, or whether the stairs were to the right gate or to the left gate. In order to break down the witness on merits, it's very important for you. Therefore, in a case of a felony, say it's a murder case. If it's a murder case, you must do a crime scene visit. Make your own notes, take your own photographs, take your own videograph. So tomorrow, you may contradict the witness and impeach his credit in hundreds of ways. So, for example, I remember there was a witness in Arushi Talwar double murder who claimed that, he used to come for a morning walk after traveling a distance of about 35 kilometers. I said, you are one hell of a walker. Who came to walk near my client's house from a place 35 kilometers away. When 10 questions or few questions were asked about the structure of stairs, the doors, and the apartment, he fell apart. How did he fell apart? Impeach the credit of the witness on merits using the power under 155. All fact-based. Who did you meet there? Some cop, sir. Do you remember the name of the IO? No, sir. Then you may be able to show, please have, sir, here is the chief, here are 10 answers. And the witness, sir, it seems that is completely planted. Why is he planted? You don't say because he's planted, because he's there, I could read. No. Because in comparison to the chief, and when you look at the cross, he's completely lost. Merit cross, therefore, is very important, and it is guided by two principles. A, your defense. B, by your crime scene visit or your understanding of the truth. Third chapter of a cross, my friends, is counter defense. If you have an alibi, that comes under chapter 3. Now, you cannot start with your alibi in defense evidence. You have to give your alibi to the prosecution witnesses right from the beginning. Remember, a good lawyer consistently has a same defense right at the stage of charge, right at the stage of PW1 to the last prosecution witness who is the IO. He has the same defense in 313. He has the same defense at the stage of defense argument as well as the final argument. Third chapter is counter defense, which means if you have an alibi, somebody says, this happened at 8 o'clock. Your alibi is that I am in Kanpur. Then you will say that, look here, madam, you are saying this, but I am in Kanpur. Have a look at this photograph. When you are saying that something has happened from 8 to 8:30, I am making a phone call from a tower, which is about 35 kilometers away. How can I be there and here simultaneously? In Unnao rape case, I was able to manifestly demonstrate on merits that between 8 to 8:30, the prosecutrix was talking on a phone, which was admitted by IU. 7:52 to 8:16, the prosecutrix is talking on a phone, admitted by the IU. Still, there is a conviction. Yes, it can happen. No issues. That's the fate. We have to bow our head down. Question is, what did I achieve? I achieved a fact on record by cross-examination on merits under 155 that, Your Honor, the prosecutrix is a liar. How? Why? Because she can't be raped and she can't be simultaneously talking on the phone and make 3 calls between 8 and 8:30. I'm making 6 calls elsewhere. Good, bad, or ugly. Third chapter, therefore, counter defense. So counter defense is given to each witness. Cross-examination on merits is done to each witness with 2 interests, 2 objectives: to impeach the credibility, not only on the substance of the statement, but also to bring in contradictions between what one witness has said, what another witness has said. Sometimes you pit a witness between themselves without they even knowing what has happened. The last chapter of a cross-examination, most mandatory, is suggestions. So you have to give a suggestion to each assertion in the chief. Why? If you do not rebut what has been said in the chief, it stands like a third thumb. Under 57 of Indian Evidence Act, you are therefore deemed to have admitted what has been stated in the chief. So my friends, cross-examination, remember, in 4 separate chapters. Prepare each chapter. You must have a questionnaire ready. Each chapter. Contradiction. अगर आपके 25 contradiction निकल गए, ये लेके चल लो कि 25 में से 5 ऐसे होंगे which will certainly fetch you an equity. Can be a good luck also, sometimes bad luck. Ultimately, what happens is, if you do a good trial, your client will get the benefit of a good trial definitely somewhere. That's what I firmly believe. So to close it from a point of view of cross, Though I would love to show you a cross-examination, that's going to take time. So today it's only a discussion and a bit of a deliberation on basic principles. So you must have your tabular charts of contradictions ready so that you can pinpoint, a merit questionnaire ready. Not yet, I will think and ask, पता चला कि भाई वहां ऐसा भी कोई सवाल पूछ लिया जिससे prosecution का ही case crystallize होगी. Secondly, remember, the most important art of a cross-examination is not what not to ask. Remember, you should always remember, don't ask something which unnecessarily introduces an admission. You don't give a chance to a witness to bring in an explanation. So never ask a question to a witness. Madam witness, please tell me, why did you say this to the police and why did you say differently to the court? Here comes the explanation, you're done and dusted. So the whole purpose of contradiction is ruined. A cross-examining lawyer takes advantage of a contradiction, not to seek an admission or an answer or an explanation on a contradiction. Importance of cross-examination is so great in a criminal trial or a civil trial because the whole case is built on it. So in order to close this, I'll give you two examples. And let me say it very clearly on a public platform. Mr. Chautala faced a criminal trial for corruption in a court at Patiala House Court in England. Witnesses came, testified, 10 years conviction. In the appeal, legendary, there has never been a bigger lawyer cross-examining than Mr. Ram Jethmalani. He was engaged in appeal. And he himself said that, Mr. Mir, I charged a fees in crores. I can even tell you what was the fee per hearing. Ran into, I don't know, God, that kind of a money, the whole lifetime will take in even counting. So he argued the appeal before a single judge in Delhi High Court. Appeal was dismissed. In Supreme Court, on the first date of hearing in limine, the appeal was dismissed. So why did you lose? Well, it's not only destiny, because right from the beginning, the building blocks were not in order. Your trial was ruined. You were not able to demolish the witnesses. If you were not able to demolish the witnesses, then even Jethmalani can't help. In comparison, for example, I went down to Ghaziabad court and cross-examined in Arushi Talwar. So I remembered that I did super quality work, according to me. I smashed the CBI witnesses to smithereens on each count. 40 witnesses came, and according to me, I cross-examined out of them about 28. Out of that, 25 witnesses came to a cropper when their cross-examinations were seen and compared with the chief. Unfortunately, it all happens in the system. My trial judge convicted both of my clients. So we went into an appeal in 2016, argued the appeal for 4 months, commit the exoneration. Now, there was no maverick argument in the appeal. It's not right to privacy. The same chief, same cross was read. And what did the High Court do? High Court do? Incomparable strictures against CBI. You tampered with case property. You coerced and intimidated the witnesses into changing their statements. Horrendous strictures against the trial judge. The High Court stated that somewhere you were like, some kind of a mathematician trying to solve a puzzle. And sometimes you were acting like a film director who already had a plot in his head, and you were trying to justify that in the judgment. The first appellant in Arushi Talwar Hemraj double murders in the Supreme Court is the trial judge, not CBI. So remember, my friends, if you do quality trials, your clients are bound to get that benefit. If not in the trial court, definitely in the appellate court. That's why you win the cases. You don't win them on arguments. You win them on the quality of the trial which was done. I would like to close
Delight to
today.
hear you. We just want to keep listening to you, but due to paucity of time, we'll obviously call you once again for another
Yes,
session where you can demonstrate with the kind of questions you had asked, perhaps in Arishi Talwar or in any other case.
yes,
But if you could summarize in quick 2 minutes.
yes. So that's exactly, Sanchita, what I was trying to say to my friends now to close with. That my friends, remember, in order to be a good defense lawyer, you need to have, you need to keep on reading the provisions of Indian Evidence Act, like some of the provisions which I demonstrated today, CRPC, judgments relating to how evidence is led, how evidence is scrutinized, and they will always be your probaris. Remember, when any person has a brush with criminal law, he only has two saviors. One is his faith in Almighty God, if he believes in God. Second is his trial lawyer. His trial lawyer writes his destiny. A good lawyer, trial lawyer, will write a good destiny. Ordinarily, one will basically destroy the destiny. You want to be a good trial lawyer, you'll be a superb arguing counsel as well, because then you can better advise. So, Sanchita, I would like to close this. And please, if anybody has any questions, please go ahead. I would love to answer the questions.
Sure, please raise your hands if you have any questions. I'll unmute you. Or you can write in the chat box as well. Bhavani has a question. Bhavani, you can unmute yourself.
Sir, good evening, sir. I have one question, sir.
Yes.
Yes, Bhavani, ask
Sir,
your
if a
question.
client, witness or accused, not cooperating for our cross-examination, fully not cooperating, in that case, can we demand his kith and kin to put in box for cross-examination?
Sorry, come
If he
again.
doesn't cooperate
If a witness
if
doesn't cooperate,
accused or witness fully not cooperating, can we demand his kith and kin or a family person put in a box for cross-examination instead of him?
well, certainly, if I could understand your question properly, is that if a particular witness is necessary for the purposes of the trial, be it prosecution or defense, whether that witness can be compelled to come into the box, yes, he can. So if you remember the famous Nitish Katara murder case, where his purported love interest was sitting in England, and she was a prosecution witness and she didn't want to come. So the court issued a non-billable warrant and compelled her to come down from England and to testify. So by cooperation, if one could understand two ways, is that if the witness is trying to avoid, yes, the court will then issue a process and issue a non-billable warrant against the witness and compel the witness to come to the court, because ultimately somebody's fate hangs, in balance and depends upon the testimony. Second is, if the witness is not cooperating in the chief or the cross, then you will ask the judge to record the denouement of the witness. The judge, remember, also has the power to ask questions directly under a provision called 165. If the judge records in the court order that witness is not cooperating, take it for granted, then that witness is worthless. So even if he has recorded a chief and he's not cooperating in the cross, his chief will be rendered redundant. That witness will therefore come in your favor.
Abid, I hope this answers your question. I hope your question is answered. And Abid, I hope your question has also been answered. He had a similar question with regard to section 165.
Thank you, sir. Thank you, sir.
Parveen, you can go ahead.
Hello. Good evening, sir.
Yes, good evening.
Sir, my question is, in case of maintenance and DV cases, for showing contradiction, is it mandatory to show evidence during cross of petitioner or can we exhibit that document during respondent evidence stage?
No, you see, the moment the process in a DV suit is always in terms of 125 CRPC, which means that the complainant will step into the box to offer herself for a cross-examination. But perceptibly, her chief can be on an affidavit. And when in a maintenance suit, whoever is asking, maintenance steps into the box, then all your provisions of contradiction, 145, 155, impeaching the witness, is already available in your hand. And you can seek a contradiction, in terms of the affidavit filed, documents placed on record by the complainant, and the complaint so filed. You can also seek to contradict a witness by a document that may be in your hand and impeach the credit of the witness thereby. Then it is not necessarily that for the purposes of demolishing the witnesses, you will provide a counter testimony. Rather, that will be foolish and will render the cross-examination unnecessary. If that kind of a procedure is followed, then we will say, okay, you come in chief, I will not cross, then I will come in chief, all right. So we cancel each other out. No, that can't be done. Your duty is to demolish the witness when he steps in his testimony, not physically.
But
I'm sorry.
but sir, can we do that practice also, that during respondent evidence stage, means suspend evidence stage, we can exhibit all the documents which will show that petitioner is lying? We can.
Well, of course, you see, when in a DV suit, it's like a civil suit. When somebody files a claim, you file a written statement. Along with written statement, you file your list of documents. When your chance or when the law provides you an opportunity to provide your testimonial account, you will then exhibit your documents. In terms of 62, 63, and 65.
I think he also intends to ask if you can surprise a witness with a document and then.
No, you can't. You can't bring in a document out of your pocket. Even if you have to file a new document, you have to file an application to that effect.
Right. I hope that answers your question.
Fair enough. Next question, please.
Jaymala, please unmute yourself.
Yeah, good evening, sir. First, I'd like to thank you so much for such an enlightening section of for cross-examination. Sir, I wanted to ask you about regarding WhatsApp messages, evidential value of WhatsApp messages, and that too when there are recent judgments or settled position of law now, like service on WhatsApp is acceptable service, whereas messages exchanged between the parties on WhatsApp, what is the evidential value of that, or how law is evolved for that WhatsApp messages, as far as particularly for family matters, sir?
All right. You see, at the end of the day, this question is not very difficult to answer, and you as a lawyer can certainly grasp it at any point of time. Any evidence which is core electronic evidence in nature is admissible in terms of what we just debated. That is section 2, what evidence is all about. So it's not that WhatsApp evidence. So what is WhatsApp? WhatsApp is basically an exchange of, rather than having a conversation on phone, you're exchanging conversation by sending data packets, right? At the end of the day, it's an electronic piece of evidence. When you adduce electronic evidence, you have to be mindful of again, section 62 and 65B and 65C of the Indian Evidence Act, which means that if you, for example, have a mobile phone, let me say simple. This is also, at the end of the day, an electronic. There is a conversation. You're talking to me, I've taken your conversation. And the conversation is now recorded in the hard disk of my mobile. If I want to prove this conversation, I have to produce this mobile before a court. Now, if this conversation has taken place on a platform, let's say Facebook chat, correct? let's say WhatsApp chat, let's say a Telegram chat, then it is through an interface, which means that any person who is trying to adduce that evidence has to prove the authenticity of the platform as well. So you have to provide a Section 65B certificate regarding that conversation. You may also need to provide a testimonial account of the platform itself, which is, for example, WhatsApp or Google or anybody of these people who operate these platforms, that yes, what was exchanged was perfectly all right, and it was not tampered somewhere or changed somewhere. So WhatsApp conversation, lock, stock, and barrel, initially and entirely is not inadmissible in evidence. It can be adduced in evidence subject to the compliance of requirements of electronic evidence. You see, the famous judgment of 2014, 3 judges, that is P.V. Anwar versus P.K. Bashir, says electronic evidence is susceptible to overlapping, excision, cutting, interpolation. सर किसी का लगा लिया, हेड किसी और का है, बॉडी किसी और की है, बोल कोई रहा है, आवाज किसी की है. Like JNU tapes. Now JNU tapes are fudged. This whole case about JNU, they're fudged tapes. Who is talking? The man is not talking, somebody else is talking. The words have been interpolated. That is why you need to be more careful. The court needs to be perfectly careful in admitting that evidence. But the door is not closed. So court can't say, if it is WhatsApp, I'll not even let you, come into the court. Thank you very much, get out. That is not possible. But you have to prove 2 things, primary evidence, and if there is an interface, then you have to ensure that the interface did not violate the authenticity of the electronic evidence. That is why WhatsApp says encrypted. Means कि सिर्फ इसके अंदर हमारा कोई हस्तक्षेप नहीं है, जो आपने बात करी है सही करी है, और जैसे करी है वैसे ही गई, जैसे वहां से लिखी गई वैसे ही इधर आ गई. But you will need you to testify, provide this device, provide a 65B, and also ask the platform organizer to testify. There you go.
Okay, thank you. Thank you so much, sir. Thank you.
Welcome. Next question, please.
So there's a question on right to remain silent of a witness. So I thought we can just refer to sections 132, 147, 148.
Yes. So right of silence, you see, at the end of the day, right of silence is like 5th Amendment of American Constitution. Like in United States, you say, somebody asks a question and you say, I exercise my 5th Amendment rights. That is right of silence. In an Indian court of law, the witness cannot and is not permitted to remain silent, because at the end of the day, the witness is called to the court to provide a testimonial account in regard to the fact in issue. If the witness is relevant, then he has to testify. If the witness in the cross remains silent, then that will entail his examination in chief to be rendered redundant and cannot be considered as a testimonial account admissible in evidence for the purposes of judicial scrutiny at the stage of final arguments.
Right. I think so.
Yes,
so
please.
We can stop here, and whatever questions rest of you may have, you can send it to the organizers.
You may ask 1 or 2 questions, no issues. Right. I don't want any of the law students or younger lawyers to go unheard. So let's have 2 questions to close, and then we can close the session.
Yogesh, you can go ahead and ask a question.
Yes, ma'am. So Evidence Act, Section 146. 1 minute. Second point.
Yes.
So what is 1 minute?
Here it is, 146. To discover who he is.
Yes, ma'am.
Yes. So what's your question?
Yes.
What do you mean position in life?
Sorry?
to discover who he is and what is his position. What do you mean here? What is his position? Position in life. Meaning of position in life.
See, if for example, some witness, now this clause is there in the statute as per 146, primarily to test his veracity. Secondly, who he is and what is his position in the life are given there for the purposes of in relation to the fact and issue. If a witness comes to the court and he tends to make a statement which has a pertinence on his position, for example, if he holds a position of chief of the staff, then that may be relevant to the controversy. Or in his own life, means that he may be a scientific expert, he may be a forensic expert, he may be a defense expert. So if, for example, tomorrow a DNA expert comes to a court, a handwriting expert comes to the court, that's a position that he holds in his life. So your duty at that time under 146 is to shake also his expertise. Now, let me tell you with an example that in these Arushi Talwar Hemraj double murders, I got a witness from England to testify for DNA. My purpose was to show to the court that the Indian expert who testified for DNA lacked expertise. So therefore, I was attacking 146 subclause 2 to show to the court that the person who chooses to say that I am an expert and I hold this position and I hold this stature is actually not a man who's worth it. That's what 146 is all about. Last question, sir.
There's a Dot who wants to ask a question. I don't know your name, so I've unmuted you. Please unmute yourself and speak. You have been raising your hand for quite a long time. No? Okay, so
Good evening, sir.
right.
Okay.
So I have a doubt. I mean, probably I have a question which the answer might be very subjective.
Okay.
During court examination, how do you question to a witness who may be very sensitive?
We can't
Sorry,
hear you. Can you be a bit louder?
Your voice is coming in a garbled tone.
Am I audible now?
Yes,
You are
please go
audible
ahead.
now.
So during a cross examination, how do you put questions to a witness who may be very sensitive in nature? A sensitive in the nature means by virtue of how that person is related to the case, probably a victim of a sexual assault or a rape, or maybe parents of the deceased. So how do you put questions to them?
Okay. No, you see, any witness who comes to the court, comes to testify on a criminal charge. So, whether the witness is sensitive or not, doesn't matter before a court of law. A witness is a witness. Of course, in a case of sexual felony, the victim will come and testify. Ultimately, the fact, if there is a murder or, there is a felony of broken legs, there is an attempt to murder, that's a fact. The question before the court is who did it? So similarly, in a case of sexual felony, somebody says that there is a sexual felony. Question before the court is, did the accused do it? So if the witness comes to the court and somebody says it's a sensitive witness, well, you're more than welcome. The cross-examination is not there to beat you up. The ultimately witness is always a guest of the court. You don't browbeat a witness. You ask him questions in accordance with law, which are necessary. But for that, you have to seek a divorce from emotions. You should not judge your client. And you should not look at a case from sensitivity point of view. You're there to do a job, do it.
Thank you, sir. Thank you so much. It was a lovely session. Shivangsh will speak a bit about the courses and webinars that they're going to hold after this. But so we just want to thank you so that he will continue after this. Thank you so much, sir. Thank you for being here. Thank you on behalf of everyone present here. It was a very, very enlightening session. I'm sure it's going to help the students a lot. Thank you, sir. Thank you so much.
Very well. Thank you very much for inviting me. And I wish everybody the best. And may you all succeed in your lives. And, before I close, I'll tell you, as I learned from my friend, that, you just have to, do your basics correctly. You have to believe in your abilities, build on them, and you have to have ability to dream. Only then the dreams come true. So may all your dreams come true. And I'm available always. If you want to give me a phone call, you need my help, anytime in any trial, you want to ask me a question, just shoot. You can take my email, write a question to me. I will definitely take out time to answer. Thank you very much and have a nice evening.
Thank you. So thank you. Participants, you must stay back. Shivansh will tell you more about the other webinars and courses.
So we have a course structured on the criminal law and litigation with Sanchita ma'am. So
Shivansh, you have to be louder and more energetic. You can't be talking like this. So basically, we had an amazing session on cross-examination today. So what we have been trying to do here is to train you guys in doing criminal litigation, because you all will go out in the world and then use your skills. At that time, all the knowledge and skills combined together will come to your rescue, and not what you have written in your exam, right? So therefore, in order to do that, we have devised a few webinars and workshops to help you in your career later, because otherwise, for example, I have 6-7 associates working under me, so I don't have the time to kind of then train them to how to do this, how to prepare. I mean, it had come intuitively to me, and I realized not many people know how to share it, even if they know how to do it, right? So first, the willingness to share, and then the ability to train people has to be there. So therefore, when Shivansh got in touch with me, I thought, let's do something together of this sort. So we have devised a course with great effort and patience to help you guys in less amount of time, to prepare you all, to train you all in practicing law. And particularly one of these courses relates to criminal litigation that I will be teaching. And we will be covering, of course, you heard about cross-examination. We will be covering the how to do cross-examination. We do it with the help of demo, with the help of exercises, where you will get an opportunity to prepare your own set of cross-examination questions. All that we'll do, we'll give you with, for example, today I didn't have time to share this with you, but we will provide you with, say, 10 commandments of Professor Irving on how to cross-examine, what to keep in mind. That will by and large cover all of that you have done in today's session. All this we will be doing with you: drafting of bail application, drafting of complaints, what happens pre-trial, what happens post-trial. All of that we will be covering in the course. But before that, even if you are not sure about what the course would give to you, so we also have a few workshops and webinars for you, the details of which will be given by Shivansh. Please go ahead, Shivansh.
So firstly, we have the course structured on the criminal law and litigation, which is structured into the completely live sessions on the weekend, which is starting from the 5th of February. And before that, we have a workshop on stages of a criminal trial too, which is a 2 days extensive workshop in which ma'am will be dealing with
Can you give the dates, Shivansh?
that will be from 22nd of the January.
Right, 22nd and 23rd January.
Yeah.
And that is on?
That is on the live that will be conducted by this, that is on the topic of the stages of criminal trial.
That's
drafting of bail applications.
Right. So there will be a workshop on stages of criminal trial and bail applications on 22nd and 23rd of January. And
we have a course which is starting from 5th of February.
Right.
Completely
so 5th
live.
February the course starts, and Shivansh has shared the link with you, which is right here. You can access, for all those who are watching it on YouTube, it will be shared on YouTube as well. So yes, so this is the link to the course. You can have a look. If you have any questions, you can get in touch with the organizers at, if you can give your email ID as well, if you can type it out, where they can get in touch. With regard to this webinar, if you have any questions, we can also send you some material that will help you in future or whenever you are practicing, right? Okay, there's a discount as well. Shivansh, go ahead.
Yeah, so we have a discount coupon for all those who are attending today's webinar, and Shivang must have shared the link with you. So on that link, you can enroll and get a rupees 500 discount if you are registering within 24 hours. That discount will be applicable to you guys.
Perfect. Anything else? Thank you so much, guys, for being so patient, for being here for 2 hours. This is like wow, but of course, Tanvi sir is an amazing speaker, as well as he covered all the points really well. We hope to do that in future as well with other resource persons and during the course. Anything else you would like to add, Shivansh, or else we can close? Shivansh has shared the email ID where you can get in touch, support@lawcommunity.in. Yes, please.
Thank you so much, ma'am, and thank you so much for enlightening the beautiful sessions. And thank you so much, everyone, for joining in.
And who are you? Why don't you introduce yourself?
So basically, I'm a co-founder at Law Community, and I'll be working and spreading the knowledge.
And you're still a student. That's like, wow, right? So he's a final year student who is working quite, I mean, you can just get in touch and you'll know more about him, about the kind of work he does. Thank you so much. People are writing it was a great session. Thanks to you that were patient and we could have it for this long. See you in future with many more such sessions. Please, you can write if there is a certain aspect you want to work on, right? A certain skill you want to develop. It may not be related to criminal litigation per se. If there's something you're struggling with, do let us know and we will try to do a session with you on that. Okay. Thank you so much, guys. It's a pleasure to be back because I was teaching online for a while, but due to COVID, I had to stop. So, of course, there were students from my Supreme Court litigation course who kept coming back to me for support before your exams. And they have been asking me when are you taking your next course. So it's great to again start with Law Community. Hoping to see many of you or some of you. Right, I'm really excited about the course. Do let us know what you think. You can also let us know what all you want us to include, cover. It's a very, very customized course. We will do as per your requirement, your need. So do let us know that. Anybody who would like to share something, we can unmute because you all are here and I would like to hear what you think about today's session, how we can make it better next time, or what you think about the course, etc. Please, if anybody wants to speak, please raise your hand.
And we have shared the feedback link for you guys. You can just fill it out and just get to know more about.
Right. Anybody would want to say something at this stage? No? Arushi, do you want to say something? Megha, do you want to say something? Anybody? Satyaki. Satyaki, I have unmuted you. Please speak. You can speak now.
Ma'am, it was an honor actually to hear you once again. I don't know whether you remember me. I am from that moot court final.
You won the competition that we judged, that I and Mr. Mir had judged.
No, I was the runner, sir, but I won the best advocate award.
Yes. That's what I remember you winning the speaker. Yes.
Yeah, it was actually honor of hearing from you guys, hearing from such an esteemed panel once again. So many concepts got cleared. Thank you so much for giving us this opportunity. I just wanted to thank you so much actually. I'm feeling very grateful actually and lucky actually. So many crucial concepts are getting cleared and revised at the same time. Practically also we're getting to know how they work. So just thank you so much and thank you Shivansh also for this opportunity. Thank you so much.
Great. So thank you. I think we can close this session. It's already too late. Thank you guys for being here. Shivansh, go ahead.
Thank you so much. Thank you for attending. We'll see you in the next workshops and webinars. Thank you.
Thank you. Bye. Have a nice evening.